Hey, hey, I think we're back. I think we're back. Okay. All right, let's see. Just a second, guys. All right. All right. So sorry about that. I think what happened is the 24-hour lease on my hotel internet expired, and I had to renew it because of the live stream last night. So, you know, we should be good now. We should be good now. Hopefully everybody, the echo should be fixed. Sorry, I was pulling it up on my phone to make sure that it wasn't just fooling me on the on my PC's chat here. No. It's complimentary internet. I think you just have to renew it every 24 hours. So, all right. It's definitely not my fault. Nothing I did wrong. Okay, so like I was saying before we got shut down by the man, we're going to go through the withdrawal motion and then the order to show cause, because the order to show cause isn't that's just a proposed order, and the juicy stuff is in the motion to withdraw. And then after that, we'll read through the Patreon hearing transcript, which dropped today. So, without further ado, I'm going to shut down by shut down, I mean, I'm not going to pay too much attention to the comments as we push through the documents. And then if you have something, certainly, and you want to get it out, send a super chat, of course. And if you don't want to do a super chat, I perfectly understand. Go ahead and just save your comment for the end. I am trying to arrange all this on my screen, but save your comment for when we get past those, for when we get past the documents. So that way we kind of focus, and it makes a little smoother playback later on, even though I've already spent 20 minutes not doing what I said I was going to do. So let's get to that before the shutdown happens again. Yeah, guys, I was furiously checking my email. I'm did some idiot somehow get the stream taken down? Because I haven't even done anything. But all right, here we go. So this is the affirmation of Kevin Landau in support of petitioner's motion for an order allowing petitioner to withdraw as counsel. Withdraw, Kevin. And for a charging and retaining lien and disbursements. And that's really what this is probably all about. When we get down to it, it's probably about money. And we'll talk about that as we go. But let's go through this as normal. I'm an attorney admitted to practice law in the state of New York and counsel to plaintiffs herein. I have personal knowledge of the matters set forth below, and the exhibits annexed hereto are true copies of the original documents. I submit this affirmation in support of petitioner's motion for an order to show cause allowing petitioner to withdraw from further representation of plaintiffs George Uzunian and Jessica Blum. Hereforth, plaintiffs, pursuant to CPLR 321 and regarding petitioner's entitlement to a charging and retaining lien pursuant to Judiciary Law for Section 475. Filthy Phil, I finally caught a live video. Well, welcome to it, buddy. I'm glad you're able to do so. You're just in time as we're getting into the document. Jesse Samuel Anderson says everyone should both target and harass. As always, no one should copy any of these. No one should talk to any of these people. But just know that now that litigation is potentially over for Kevin Landau, I will be sending my letter to him to request an appearance on this program, which I would very much love to have. So I will keep you posted on that. Garrett Davis says, cheers rackets for distracting me from the ending of a 12-year relationship. The rest of this is just to get my full $5 worth with all 150 characters. Well, buddy, I'll toss one back for your relationship. Sorry to hear it didn't work out. But, better things are on the horizon, my friend. In the meanwhile, take your time and wallow in your misery, and don't let anyone tell you don't need to. Do what you need to do, buddy. Okay, so here we go. Back to it. We're on paragraph 3 for those keeping track at home. On or about August 18, 2017, petitioner was retained as counsel to represent plaintiffs in a lawsuit against a variety of defendants, namely Asterios Kokkinos and Dax Herrera, for invasion of privacy, defamation, tortious interference, unfair competition, and intentional infliction of emotional distress, arising out of a variety of social media postings, podcasts, and internet harassment campaigns. Still don't know what that actually is. Pursuant to this retainer agreement, petitioner spent a substantial amount of time conducting the necessary research and drafting a complaint spanning 50 pages, which contained 16 causes of actions against 10 different defendants. Let's talk about that for a second. Let's see. So that was from Niels Abel. Cheers, Nick, sipping on an old fashioned. Cheers to you, buddy. Enjoy that drink. Enjoy that drink. So here we go. Guys, take away all prejudice towards Maddox for a second, okay? Take away every negative feeling towards Maddox. Except for one, rely on Maddox's unending incompetence. Do we think that Maddox came up with 16 causes of actions against 10 different defendants? Pirate Chan says, works on contingency? No. Money down. Think about this. Did Maddox come up with those 16 causes of actions? Did Maddox suggest the 10 different defendants? And maybe he did, but did Maddox go, you know what? That Jordan Cope piece of garbage customer service rep, I need him in this lawsuit. That Joshua Kaufman, I need him in his lawsuit. Which one? Now, is it more likely that he did that, or is it more likely that the petitioner, in this case Kevin Landau, said, well, you might have cause of actions against all of these different people? And if we go through and look at the history of filing that Kevin Landau has done in other cases, in cases not involving Maddox, I think we might find the answer, because he certainly has a habit of writing lawsuits that join in tons of defendants frivolously. Over and over and over again. So, and then he spent a substantial amount of time conducting the necessary research. This guy practices in New York, and you can barely find a hint of research done on this. Because with even a hint, he would have known there aren't anywhere near this many causes of actions, and half these defendants should have been immediately dismissed. Immediately. Drafting a complaint spanning 50 pages, which does not need a comma. You don't need a comma. After complaint. Drafting a complaint spanning 50 pages is one thought. Anyway. So here he is stating all the work he did, presumably at Maddox's request, but I have a feeling it might have been at his own request or his own behest or whatever you want to say. So, naturally, the defendants contested plaintiff's complaint and filed 4 separate motions to dismiss, which required close to 100 pages of briefing by plaintiffs, many of which they went ahead and repeated over and over and over again. C. Herrera motion to dismiss, docket 20. Plaintiff's response, docket number 77. Kokkinos motion to dismiss, docket 31. Plaintiff's response, docket 66. Weber-Shandwick motion to dismiss, docket 37. Plaintiff's response, docket 91. And Patreon motion to dismiss, docket 50. Plaintiff's response, docket 98. Guys, I've been talking about this for a long time. When you sue everyone on earth and they all get different attorneys, it costs a fortune. It costs a fortune because this dummy had to reply to every single motion. I mean, maybe he's not a dummy because each one of those 30-page responses, remember the what is it, the ramshackle affair, a 30-page rambling mess, right? Each one of those takes hours to write, even if he's not really doing a good job. They just take time. They just take time. So he's got right here 100 pages. How long does it take you to write 100 pages? It's going to take hours and hours and hours. So, yeah. And each one of those, $600 a pop. $600 a pop. On or about May 16th, 2018, the court held a hearing on 3 motions to dismiss with lengthy oral argument, which at times became contentious. Did it become contentious at times? Kokkinos' motion to dismiss was granted without prejudice with leave to replead. Further, the court noted that plaintiff's complaint, quote, could plead legitimate causes of action against New York defendant, well, Mr. Kokkinos. Yeah, he left off the, I can't tell what's being said here, so maybe it could. It wasn't actually saying they were legitimate, buddy. It was literally saying that it's so poorly drafted that the judge couldn't figure out if there was a legitimate cause of action or not. Next, defendant Herrera and Foundation Digital motion to dismiss was based on personal jurisdiction and was granted. However, any dismissal based on personal jurisdiction is not on the merits. That's not necessarily true, and was granted. However, plaintiffs... is not on the merits, and therefore plaintiffs could have simply filed another complaint against Herrera in California. Now, this is, again, taking the judge's words well beyond their meaning. Counsel will replead in California. The court, outside of my jurisdiction, you can do anything you want. It's a free country. Yeah, it doesn't say... He didn't say that you actually could, have a legal standing to file outside of the jurisdiction. He just meant you can try it, do what you want. So then he quotes Colbert versus International Securities Bureau. A dismissal for lack of jurisdiction over the person of the defendant is not on the merits. But a dismissal that includes lack of personal jurisdiction can also be on the merits, depending on the circumstances. In this case... probably not, but, let's just be clear. Notwithstanding the foregoing, here it is, guys. And if you want to know, one of the reasons that he was so... This is revealed now, right? One of the reasons that he was so quick to say, we'll replead in California. Let me get the replead in California. Dick mentioned that he wanted to bring back some sort of Pyrrhic victory to Maddox. Say, see, we got something. I think it looks like now the more likely case is that he has ammunition to say there can now be a breakdown in strategy. I think Maddox... the stream dropped again. Just a second, guys. Just a second. We're back. Last night, the hotel internet was it was ridiculously stable. We're talking the same bit rate for basically 2 straight hours without even a hiccup. So I was hoping it would be that way, but we're just going. We're going for it. So we're back. Hopefully it won't do that again. But guys, I've nothing I can do about it. So, okay. What I was saying is that Landau has ammunition to say what's coming up. They're going to talk about it in just a second. That he has ammunition to say that now there's a breakdown or a disagreement in strategy between him and Maddox. Or him and Blum, okay? He's going to set that up as as justification for why he should no longer represent them. But this is the important part. I think Maddox doesn't want to go on with the lawsuit. Even Maddox sees the writing on the wall. He sees that there's a very real possibility that if he sues in California, he dumps another multiple $10,000 investment down the drain, that he loses, that he potentially gets countersued in an anti-slap motion. I think that Maddox doesn't want to continue and Landau does, because Landau is squeezing dollar after dollar after dollar out of Maddox. Okay? That's what I think is going on, and I think that'll become clear as we read the document. So that is one thing that I see that I'm going to say is I'm pretty sure this is the bad side, right? This is taking Landau in the least favorable light. Raging Hot Truth says Maddox used his 1999 era hacker skills to take down the Wi-Fi. Hack the planet! This is garbage! It's garbage! Now, that is an opinion, and it is a theoretical opinion. I'm not saying that this is definitely what is happening, because obviously I do not know what conversations Landau is having with Maddox, right? Impossible for me to know what's going on there. The other side is that Landau is saying, no, you need to stop. You need to probably stop litigation because you're wrong. It's not going to work. You're putting yourself at huge risk. And Maddox is the one saying, no, we got to go on. We got to go on. I mean, I think Maddox consistently makes bad decisions. That seems to be obvious and facially apparent. But even here, man, when you're dumping tens of thousands of dollars and you get just BTFO'd in court without even a thought, and we'll see that in the Patreon dismissal. Jason Benaim says, what's up, pores, rackets? Hey, buddy. Thank you. Thank you so much. That one deserves its own. Wow. Yeah. So, I think, based on everything that we've seen about Kevin Landau, it really looks like he's trying to squeeze more and more money out of Maddox. I don't think Maddox wants to go on. I don't think Maddox likes to lose. I really don't. I think Maddox likes to win things, and losing is a direct affront to his reputation, to his ego, to what little semblance of success that he has. Like that. That's what he holds on to, is that his correctness, and losing is very much a violation of that. So I think losing here was devastating, and I think Maddox is ready to just turn in the towel and focus on his own project. So that's what I think is going on. But, I don't know. Okay, so now the reason I think that is going to come here. Petitioner and plaintiffs have a fundamental disagreement as to how to proceed in this case. Petitioner and plaintiffs have had several conversations regarding how to proceed in this case, and at the present time are in complete disagreement. Therefore, there has been a complete breakdown in the attorney-client relationship. I don't know that is an accurate representation of the standard. Because attorneys disagree with clients all the time. It's not a contest, Nick. Nobody wins. That's a great, it reminds me of a great Office quote. Jim from The Office. He sees Dwight playing Second Life. He says, "Oh, how do you win?" Dwight says, Second Life is a real life role playing game. There are no winners. There are no losers. Jim says, "Oh, there are losers." Whoa! Thank you, Raging Hot Truth. Well, now I gotta refresh my glass. Thank you very much. Of course. Wait a little more. A little more whiskey in there. Ooh. Mmm. 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 Thank you. That is a good punishment for receiving a super chat, is to have to take a drink of good whiskey. Wow. So thank you guys very much. Jesse Samuel Anderson says Asterios thinks this is because the big names are out. What do you mean by the big names? You don't have to pay. You can just tag me so I see what you mean by the big names. Oh, you mean Weber, Shanwick, and Patreon. Possibly. I honestly think, look, if Landau has any legal training, okay, which he does, obviously he passed law school, passed the bar. He knows this is a stinker of a case. He knows it's the longest shot in history, and he's been collecting money from Maddox this whole time. Maddox plays Second Life. Okay, so but here, let me get back to this. Therefore, there has been a complete breakdown in the attorney-client relationship. That was from Nicholas Melchiori, by the way, the Maddox playing Second Life comment. Thanks, buddy. I appreciate it. The breakdown of the attorney-client relationship. Attorneys and clients disagree on strategy often, and the attorneys ultimately answer to their clients because that's who's paying the bill. We provide advice, we provide counsel, but if the client wants to go one way, you make the best argument you can do in that way. Now, hopefully you establish a relationship based on trust, but when you go to court and every single person gets dismissed, and the judge says, this is so absurdly poorly done that I can't even make heads or tails of what you're trying to do. And again, as we read that Patreon transcript, it's going to be apparent just how much Ramos likes Kevin Landau. Maddox has to be looking at this like, why on earth are you involved with, why would I listen to you at this point? Why would I think that your ideas are right? You've been wrong every single step of the way. Even when I watched that one whiskey drinking lawyer's video online and I talked to you about it and you said, no, don't listen to that guy, he's an idiot. And then he turned out to be right about pretty much everything. Like, what's Landau going to say? What's he going to say? So I don't think they've had a breakdown in the attorney-client relationship based on strategy, because that's not a breakdown of the relationship. The relationship breaks down when the client no longer trusts the attorney. And in this case, the client has a lot of grounds not to trust the attorney. The Patreon transcript, I've got a copy. It was given to me by someone. I don't know where they got it, but I'll pull it up. Don't worry. We're going to cover it on the stream. So, okay. Is it from patreon.com/thedickshow? We'll see. Loose for Love Monkey says, I'm waiting in my cold cell when the bell begins to chime. What is that from, buddy? That sounds like a quote. All right. So here we go. Let's move on. Based on the foregoing, petitioner has exchanged multiple emails with plaintiffs, notifying them that a motion to withdraw as their counsel would be filed forthwith. Namely, to protect plaintiffs' legal rights and interests. Nope. No. And because there had been a fundamental breakdown in legal strategy and communication. Nothing about him withdrawing as counsel protects Maddox's legal rights or damages them. His legal rights, Iron Maiden. Okay, yeah. I'll have to get the tune. And do an Iron Maiden impression for you at some point. Nothing about this withdrawal of counsel protects their rights or hurts their rights. That's irrelevant at this point. So that's a nonsense answer, because there'd been a fundamental breakdown in legal strategy and communication, maybe, and a fundamental disagreement between petitioner and plaintiffs on how to proceed with their case. Footnote. Raging Hot Truth says, Maddox is probably still pissed you BTFO'd him on homeschooling. Probably. Kenster 1790, everything is just fine. Everything is great, buddy. Thank you. Thanks for looking out. Okay, so here we go. His footnote says, this correspondence is not attached here too because it may contain privileged information and could potentially be used to prejudice plaintiffs. Yeah, I think it might be used to prejudice you. Man, you know what would be great? And again, Maddox, of course, cannot take legal advice from me, but if Maddox does hire another attorney, he should strongly consider releasing that privileged correspondence, because how privilege works is in an attorney-client relationship, the client holds the privilege, so they can legally prevent an attorney from disclosing something, and if an attorney were to disclose something that was privileged, the client could then seek legal recourse against them for any damages that it would sustain, and those damages could be presumed because you're just not supposed to breach that. Maddox has the final say. He could release Landau's email. He could say this, if this is what happened, he could say this shyster swindled me and all this stuff, and then now he's trying to get out of it. So that's up to Maddox. It very well may really look bad for Kevin Landau to see what's in that email. If Santa is real, if Santa Cuck is delivering for Christmas, that email will come out. Okay. However, petitioner will provide said correspondence to the court in camera, in private, or with the permission of plaintiffs if necessary. Yeah, sure. Man, I wish Maddox would authorize the release of it. Hughie Pahagat. Nick, what night in a given week are you free for a couple drinks in central Minnesota? Please read my name properly this time. I'm free a lot of nights, buddy. Contact me on like Twitter or something so I can have an easy way to access the thread and get some contact info for you, but we can probably make that happen. Jesse Samuel Anderson says, would Maddox hire someone to fight this? That's up to Maddox. We'll see. And buddy, I can't pronounce your name without potentially getting streams demonetized and stuff like that. It's Pride Month. People would take really, really nasty offense to that. I don't know why, because clearly we're talking about bundles of sticks and not talking about anybody else. But that's the way of the world in 2018. Speaking of which, so just brief sidebar. My kids are watching Nick Jr. today because we're in a hotel. And there's like a 60 to 90 second ad about Pride Month with a bunch of kids talking about what they're proud of and what they take pride in that they do, but then running around with like rainbow flags and stuff, and like some insinuation that some of them might be LGBT or whatever, because like one girl says she's a tomboy or a bit of a tomboy. I guess I shouldn't say it's a girl. Or one person suggests that they're a bit of a tomboy or something like that. Like this is what twerks people off, right? Like you're having an ad for Pride Month, and kids are going to be thinking that Pride Month has something to do with something other than LGBTQ, but that's not what Pride Month is, right? Like, why disguise what you're doing? Why Nick Jr. are you advocating participation in Pride Month, but under false pretenses? Like I think if Nick Jr. wants to advocate, for Pride Month, then they should do it under the premise of what Pride Month is. So little weird, little strange. Whatever. I don't think anybody knows what they're doing, especially in old media. So who knows? All right, back to the document here. So, CPLR 321B allows for the withdrawal of an attorney of a pending action upon motion on such notice to the client of the withdrawing attorney and to the attorneys of all other parties in the action. An attorney may withdraw from representing the client on good and sufficient cause upon reasonable notice to the client. Okay, there we go. Let's see. Power Cage says Landau is like the lawyer from Fear and Loathing. Garrett Davis says a meager pittance from the proletariat. Thank you guys both for the super chats. I really appreciate it. Raging Hot Truth says Nick Jr. has always been trash, though. Yeah, and I mean, don't get me wrong. I don't even know like what happened to animation. I don't know when Pride Month became a thing, but it's been a while. It's been a while. Brandon, we're actually about 45 minutes in, but we had some real technical difficulties known as internet shutting down. But so okay, back to the document again, and I'm gonna again trying to enforce the super chat rules, but as I keep drinking, I get worse and worse at it. But let's get through this document for the benefit of our later listeners. And I do have the full recording. It's been running the entire time, even when the stream was down. So that'll be released in audio format. Okay. So under the professional rules of the rules of professional conduct, Rule 1.16c, a lawyer may withdraw from representing a client when 1. Withdrawal can be accomplished without material adverse effect on the interests of the client, or the client insists upon taking a course of action which the lawyer has a fundamental disagreement, or the client fails to cooperate in the representation or otherwise renders the representation unreasonably difficult for the lawyer to carry out employment effectively, or the client knowingly and freely assents to termination of the employment. Paragraph 16. As set forth more fully above, plaintiffs and petitioner have a fundamental disagreement as to how to proceed in their case, which constitutes good and sufficient cause for petitioner to withdraw. And guys, being fair to Landau here, he definitely shouldn't say what the disagreement is. So like I'm speculating about what it is. He is not shady for not saying what it is. What just happened there? Go away. That's, he should not say what the disagreement is, because that would be detrimental to Maddox to say what the disagreement is, but Maddox could say it. So that's what I hope happens at some point. Petitioner may withdraw from representing plaintiffs, and withdrawal can be accomplished without material adverse effects on the plaintiff's interests. So see DeMauve, Morris, Levin, and Shine versus Glantz. A client may at any time, with or without cause, discharge an attorney in spite of a particularized retainer agreement between the parties. That's a little bit different. That's a weird legal citation there, because that's saying that the client can discharge the attorney, not that the attorney can discharge themselves. Further, plaintiff's disagreement as to how to proceed in this case frustrates petitioner's ability to prosecute their case effectively. Again, this sure looks like Maddox doesn't want to continue and Landau does. That's what it looks like. Or at all, which constitutes good cause. In Dillian versus Otis Elevator, Inc., client's conduct and frustrating counsel's ability to defend it effectively constitutes good cause for granting counsel's motion to withdraw. Now, I don't know the Dillian versus Otis Elevator. I don't know that case. I'm going to bet that the frustration had nothing to do with the strategic decision, but it was like the client not returning phone calls, the client not answering the attorney when the attorney asked him for various information or to produce documents, stuff like that. But because again, I have no trust in Kevin Landau using a citation properly. Everyone he's used seems to be wrong. Jason Benaim says, "Hey kid, my name is Kevin. You might be gay. Let's take off our shirts and kiss." Okay, well then. So as such, there is good and sufficient cause for petitioner to withdraw from further representation of plaintiffs, and petitioner has provided plaintiffs with a substantial amount of notice as demonstrated above. Did he demonstrate the notice? I guess... What were those dates? He didn't demonstrate any notice. He just simply said there was a hearing in May where he lost horrendously, and then after that they had a disagreement over some emails. So who knows what the notice is? It doesn't really matter. Where we go? Where are we? With a substantial amount of notice as demonstrated above, Further, petitioner will send plaintiffs a copy of this motion by email and by certified mail, return receipt requested upon filing, and will upload said documents to ECF accordingly. How generous. So applicable law under Judiciary Law Section 475. The law in New York is clear and well settled. An attorney of record who is discharged without cause. Now this is interesting, okay? I'm not sure withdrawing is a discharge without cause, but because he said he had good cause to withdraw. So that's not discharge without cause, but we'll go. Why do lawyers always lay out these things, e.g. definitions of legal terms that any law worth his salt would know? Because the judge doesn't know that the attorney knows what they're talking about. And the judge has to make sure that the attorney is appropriately using a citation and is appropriately following precedent, following the law. They have to make sure that the attorney isn't wrong. And the real dark secret is a lot of times the judge doesn't actually know. They don't know. They rely on the attorneys to help them out with their research. Otherwise, a judge would be researching everything forever. Yeah, his apostrophe use is still wrong in the caption. Sad. Okay. So anyway, the law in New York is clear and well settled. An attorney of record who is discharged without cause possesses a charging lien pursuant to Judiciary Law Section 475, which constitutes an equitable ownership of the cause of action and attaches to any recovery. This is where things get really ugly if we look at this in the light least favorable to Kevin Landau, which I'm inclined to do. This means it attaches to any recovery. Let's read on. Additionally, quote, if a client discharges an attorney without cause, the attorney possesses a common law retaining lien on the client's file in his or her possession and is entitled to recover compensation from the client measured by the fair and reasonable value of the services rendered, regardless of whether that amount is more or less than the amount provided in the contract or retainer agreement. Internal citations and quotations omitted. Let's say Landau charges $600 an hour, but he's only been charging Maddox $300 an hour. If this is approved and the judge agrees, Landau then gets a lien for the amount that Maddox wasn't paying, even though they agreed to a lower amount, if his normal fee is $600 an hour. And the judge finds that reasonable based on his education, experience, and location. He could be putting Maddox on the hook for a lot of money, especially if he hasn't been billing him or if he's been billing him at a reduced rate. That's... Next, a charging lien is imposed on the cause of action, and the proceeds of that cause of action, wherever found, are subject to it, even where recovery may be obtained in an action different from the one in which the services were rendered. If Maddox were to hire an attorney, prosecute this case in California, and by some magical stroke of luck win, if Maddox were to win in California, Landau gets a portion of it. He has a lien against that recovery for either his services rendered, the billed services rendered, or a contingent percentage, which could be massive, or basically the greater of. This is dark, guys. The outgoing attorney may elect to take compensation on the basis of a presently fixed dollar amount based upon quantum meruit for the reasonable value of services, or in lieu thereof, the outgoing attorney has the right to elect a contingent percentage fee based on the proportionate share of the work performed on the whole case. I would suspect. So quantum meruit is work performed, okay? So that means that he would say, I worked, he already said 100 pages of documents. He can put together a timeline of all of the correspondence that he's done. He can time out all of the motions that he's written. He can lay out what that costs, multiply it by his hourly rate, and say, this is what I'm entitled to. And then he has a lien against Maddox where Maddox owes him that money, but if Maddox doesn't pay and happens to recover, the money goes to Landau first, before even Maddox's new attorney. So he's really putting a crippling effect on Maddox's ability to prosecute the case any further, because if Maddox wins, he pays 2 attorneys and ends up with very, very little. Or he can take a contingent portion. He would say that he's done a ton of work on this case, even though obviously it's not. What if that value is a negative? It should be. It should be a negative. Lucifer Love Monkey, it really should be. Rob Goldie says, if Landau is going for a percentage of a California filing, doesn't that indicate Maddox is going ahead with it and Landau is bailing? No, he has the option to put a contingent fee based on that, or he can take a fixed dollar amount based on quantum merit. So that's the work performed. Like I said, Landau has likely put, 100 hours into this without, that's not an unreasonable amount. I mean, heck, I've put in 40 hours into this. I have done 0 drafting, right? But I've probably put in 40 hours. So the idea that Landau put in 100 hours is not unreasonable. That's a $60,000 bill at his rate. Who knows how much Maddox has actually paid him? So my guess is that that's what he will put down as Maddox owing him. Here, as demonstrated by the foregoing, petitioner and his law firm have spent a substantial amount of time on plaintiff's case, far in excess of the initial retainer fee. Further, petitioner and his law firm have incurred a substantial amount of costs and disbursements, including filing fees for the summons and complaint, $215. Service of process fees, $300. Motion filing fees, $180. Photocopying expenses, $300. $300 in photocopying expenses. That's one of those lovely fees that lawyers like to throw on there. Do we really think it costs them $300 to make photocopies? And filing and service fees for working copies to the court, $300. What? Totaling $1,295. This is just in fees, guys. This is not including the work he's performed at his hourly rate. Okay? So again, Xerox. This $1,295 is not including his hourly rate, which I don't know how much Maddox paid him in a retainer, but I have to imagine he's put in 100 hours of work or more. His bill's got to be 50 grand plus. 50 grand plus. That's my thoughts. Again, basing this entirely on me doing 40 hours of video. This is just reading the documents and talking about it and doing very, very light research on what's out there. There's no way he's billing less than... Anyway. Okay. Motions for sanctions are also pending against certain defendants in this matter, and cross-motion for sanctions are also pending against plaintiffs by defendants Kokonos and Weber-Shandwick. Look at this. This is the weasel move right here. Upon petitioner's withdrawal, plaintiffs will stipulate to withdrawing their motion for sanctions if defendants Kokonos and Weber-Shandwick agree to do the same. I really hope Kokonos and Weber-Shandwick stand their ground and do not withdraw, because there's no way sanctions go against Kokonos and Weber-Shandwick, and there's a very good likelihood that they go against Maddox and Kevin Landau. But look at him. Again, this is a hypothetical, but can you imagine how this conversation went? Well, look, you got these sanction motions coming against you, and I can put in here that you're willing to withdraw yours if they withdraw theirs. Probably not even talking to Maddox about the fact that those sanctions are against him as much as they're against Maddox. Wow. Okay, so wherefore, petitioner respectfully requests the following relief. Petitioner be allowed to withdraw from further representation of plaintiffs in this matter, and that all proceedings be stayed pending the determination of this motion. So he's giving buying time for the sanctions motion, saying they can't be decided until this motion is determined. That plaintiff be granted 30 days to find substitute counsel from notice of entry. So that would be 30 additional days after this is decided, which the proposed hearing is sometime in July. And that that the court order a charging lien and retaining lien and an amount to be determined at a separate hearing if necessary. There it is, guys. That's what he's after. That the court order costs and disbursements in the amount of $1,295. That all pending motions and cross motions for sanctions be withdrawn. The court can't really order that. I mean, I guess no, they can't. They'd have to rule it dismissed. They can't order them withdrawn. Jesse Samuel Anderson says, counter, GoFundMe, the Asterios Legal Offense Fund. Legal Offense Fund. Offense. Kind of works both ways, right? And then granting such other and further relief as the court deems just and proper. So, guys, he's really looking for the liens placed against Maddox. Kevin Landau has turned. He has turned. Look at this. He doesn't even want sanctions. If he wins those sanctions, it was $10,000 in legal fees to him from each of them, right? Like that's the idea of those sanctions. So he's giving up his own money benevolently? I don't think so. He knows he loses. He knows he loses the sanction hearings. He's gotten just absolutely reamed at every other hearing. So he's going to lose the sanction hearings, and he may lose hard enough to where he's on the line for $10,000-15,000 to each of those parties. So he's trying to get out of that, but he's trying to get the lien on Maddox. He's turned, guys. It's really unfortunate. Maddox, if you're out there, now's the time to start listening to me. I said it a long time ago. You need to talk to another attorney about your conversations with Kevin Landau. It's looked for a long time like he has been swindling you. If he advised you to commit perjury in your complaint, if he advised you to admit to a crime of criminal impersonation in an affidavit and to admit to that perjury that you committed earlier, if that was his advice, buddy, you need a lawyer to go after him. Go after him. His representation from our end looks really, really unethical. And as dumb as we all think you are, at least me, I'll speak for myself, as dumb as I think you are, I don't think you deserve this. This is something I care about. Quality representation is important. It's one of the reasons I'm a lawyer, is to try and give people quality representation. Guys like Kevin Landau bother me quite a bit. You don't deserve this, buddy. Matt Cook says, good to see there are no plastic cups this time. Nope, only real glass here. So anyways, I wish you would have listened to me earlier, buddy. You could have had a lawyer tell you how ridiculous all of this was. We've been trying, but, there you go. Have someone look into it. This looks really shady. He's trying to get the court to allow himself to withdraw so that you don't fire him, so he can bill you. So he can bill you what he hasn't already billed you and put a lien against you. He's trying to collect money after failing miserably. He's cut and tail and run. Listen to your critics, Maddox. Okay. So here's the show cause motion. Whoa, that's ugly. What do we got? There's 2 pages. So this is a proposed order that'll be drafted. This is just so that the judge can just go ahead and sign this if he wants to. So upon reading and filing the affirmation of Kevin A. Landau, Esquire, affirmed the 18th day of June, 2018, the exhibits annexed thereto, and upon all the papers and proceedings held herein, let plaintiffs appear on July blank at 9:30 a.m., so that's left for the court to decide, at IAS Part 56, Room 238 of this court, at the courthouse located at 60 Center Street, New York, on the blank day of July 2018 at 9:30 p.m. Like, pick one. You can't pick between AM and PM. Jesse Samuel Anderson, the saddest part is most of us are Maddox fans. Yep, same here. Does my... Oh, here, I can fix that. Sorry. I always just forget. As long as it's not abused, I'll keep it up. There you go. It'll no longer hide them. No longer hide them. Andrew Polanenko says, how funny would it be if Maddox hired Greenberger to sue Landau? Would this be ethically possible? Once everything was done against with respects to Maddox and Asterios, possibly. There'd probably have to be some sort of disclosure, but I guess it's theoretically possible. Okay. And if it's Maddox fans out there downvoting me, you guys haven't been paying attention. I mean, I know you haven't been paying attention because everything you say to me on Twitter is stupid. So I know that, but you should really, really start listening. So should Maddox. All right. So you can't figure out if it's AM or PM, or as soon thereafter as counsel can be heard and show cause why an order should not be granted pursuant to 321B2, permitting Kevin A. Landau, Esquire, and the Landau Group PC law firm to withdraw as counsel for plaintiffs, and the plaintiffs be required to pay petitioner the fees and disbursements due and owed as declared in the affirmation as filed herewith. It is ordered that pending the hearing of this order to show cause, all proceedings be stayed. Ordered that A, service by regular mail upon the attorneys for each respective defendant of this order to show cause together with the papers upon which it is based on or before the blank date of June 2018, and service by certified mail and electronic mail upon plaintiffs of this order to show cause together with the papers upon which it is based blank date of June. Shall be deemed good and sufficient service. Great. Check your phone. What am I checking my phone for, buddy? You should chase all that whiskey with Ambien. Whoa. Fred Simon. Hi, George. This is what it's like when people have fans and want to give someone financial compensation for their work. Remember what that was like? Oh. Thanks, Fred Simon. I really appreciate that. So let's see. MC Beaumarchais. Beaumarchais, sorry. I'm checking my phone, but what do you want me to check on my phone? It's good to keep up on how your phone is feeling. So, guys, I mean, that's the Filthy Phil, 9:30 a.m. and 9:30 p.m. are interchangeable to Kevin. He is drunk at both times. Oh, wow. Okay, guys. So that's what we got on those. Just a second. Let me get I got to get the document for the Patreon thing. Do I still have it pulled up? No, of course not. That would have been smart. Whoa. Computer just tried to restart. Thwarted it. Almost there. Hold on. Okay, let's see. Open. Save. All right, let me just pull this up here. I'm going to pull up the Patreon transcript. Apologize for my lack of being on top of this. April 28th. No, no, no. Come on. Come on. Come on. What is this? Nope. Save. Oh, stupid thing. Okay, here we go. Sorry. Should work now. I know you guys love when I sit and like mess with my computer because that's... Oh, gosh. Okay, there we go. Folder. There it is. No! Let me open it with this one. All right. Okay. Did I miss that one? Okay, no. Okay. What someone got a super chat to get you to reenact Dad's Google history in full? It would cost a lot. Even if he withdraws sanctions, they can still follow through with theirs, correct? Yeah, like he can't force... He's asking the court to withdraw their sanctions, which doesn't really count. Like the court can't force them to withdraw. They would have to rule on them. They would have to dismiss them. Okay. All right, guys. Before we jump to the Patreon stuff, which I have queued up here, does anyone have any questions that they want to ask about the withdrawal or the order to show cause? I mean, to me it looks really bad. Let me see. Like he's trying to get the court to enforce what Maddox owes him. He's trying to stop doing work. He's trying to get himself out of the sanctions. He's trying to get the judge to issue a lien on it. It's bad. Question: how do sanctions go down? Is there a hearing? Do lawyers go into an octagon to see who is the winner? What happens? Yeah, there's a hearing. There's a hearing on the sanctions motions. They filed their motions and they filed memorandums in support. A judge would typically do a hearing, ask them to explain any ambiguities in the legal stuff, just like anything else, and then the judge would issue a ruling on whether or not they would happen. The hearings are in kind of a weird limbo place because of how Ramos dealt with them. Weber Shandwick should have a hearing coming up. I don't know if it's on the calendar yet, but at some point they will request a hearing, I suppose. And then Greenberger's hearing is kind of on hold until refiling. With Landau leaving, that could put a big delay on that motion. If the judge agrees with him, I don't think the judge would agree to stay everything while he tries to withdraw. I think the judge would want to hear the motions before he withdraws. Would you take Maddox as a client versus Landau? If we were in Minnesota, sure. But Maddox isn't in Minnesota, so I can't actually do that for him, unfortunately. Go for the omoplata. Do you think you have made more money from this case than Landau has collected from Maddox so far? I doubt it. I think his initial retainer was pretty big. I really do. He knew how expensive this was going to be. That's why he filed the motions in the way he did. So I'm sure he told Maddox that it was going to be, $10,000, $15,000, $20,000. Put it down. But I guess I don't know for certain. But I think Maddox probably paid him quite a bit to start out. Are both Maddox and Jess responsible for paying Landau, or just Maddox now that they're no longer together? Both of them. Both of them are responsible. Their relationship was not one of marriage. They've always both been responsible individually for any representation that they've done that they've received. Would you feel differently if it truly was Maddox trying to push this forward, or Jess and Landau was trying to let sleeping dogs lie drunk / hungover? I mean, if Maddox is trying to push this forward, I wouldn't be surprised. I don't think he is. But if he's doing that, I mean, he really needs to stop. He's going to lose everything. He's going to keep losing over and over again because he just doesn't have a legal claim. But I mean, my gut and what I'm reading in these things tells me that it's Landau, because it looks like the other cases in where he does similar stuff. You guys watch Dimitri Martin? I said in my gut, but what I really meant was in my balls. I can feel it in my balls. Who's your pick to play Ramos and Landau in the film adaptation? I like David Zayas for Ramos. Shouldn't Ramos be played by Edward James Olmos? If Landau withdraws but the sanction motions aren't withdrawn, is Big Kev still potentially on the hook? Absolutely. Is there any possible positive outcome for Maddox if he goes to court in California? There is a possible. I mean, he had a potential cause of action in California. He did, I think. I don't think it was a strong one, but I think it could have made at least an argument that wasn't frivolous. I don't think he wins. But when you can make an argument that's not frivolous, there's always a chance, right? So I guess it's possible. Hugo Pahagat. Fat girl at the bar is trying to sanction me for the baby I put in her. How do I back out of this case so succinctly as Landau? I think the old, you point over her shoulder, say, "What's that?" And as she turns around slowly, run for the door is the best. Let's see. How big, one website or two? I think it's 2 websites at this point. I really do. I think $50,000 to $60,000 is the type of fees that Landau has probably incurred. How big was the retainer? Probably. I think maybe. I would say maybe 15, 20 grand, but I don't know. I don't know how he does that. I don't know how his billing works. Now that Jess has left Maddox, do they need separate lawyers? No. When you're not married, the court doesn't care how hard you're dating. If you're not married, it doesn't change much of anything. Why is she not listed in this? She's listed. She's listed in the caption. Technically we don't know if the disagreements could be with her, but that's possible. I don't know. I don't know if she's been as driving of a force as people think she is. Is it a major red flag if a lawyer won't take a portion of the winnings rather than being paid up front? No. It entirely depends on the action. But it's a major red flag if the lawyer won't explain their reasoning, I'll say. Like for me, if I say, look, your chances of winning are really slim, so I need cash up front, and we need to schedule this out for payment. Like I can't take this on contingent because there's not a lot of promise to win. I've got to pay bills, and this is going to take work. Then that's, as long as we're clear on that. And that's how it goes. Can I sue Mad Cucks for restricting my freedom of speech for getting me banned from Twitter? Probably not. All right. I'm going to do a couple more here, and then we're going to move to this Patreon thing. What if Maddox is planning to file bankruptcy and so he wants the world to burn with him? That's a possibility, I suppose. Now that Jess has left Maddox, do they need to get separate lawyers? I already answered that. What are the chances that Landau's motion to withdraw gets denied? I think his motion to withdraw could be denied until the sanctions hearings are done. I mean, I don't see any reason why a judge would want to force them to stay other than that. Because it's not like it's unlikely. They have no pending action before the court, right? Like Maddox would have to refile. So court's going to let him go. But I think they wait until the sanction hearings are done. Can you speculate on how long you think Landau had this part of his plan in the works? Is this a long con, or is he flying by the seat of his pants? That's a tough one, man. I don't know. Man, that's a really good question. I want to say it kind of... I don't know anything about Kevin Landau other than what I've read. It looks like maybe it was a long plan. I don't know. How would Maddox fight this? Will Green get to fight him leaving? I'm not sure. I guess in theory, any of the opposition attorneys could oppose his withdrawal as counsel. Greenberger and Munoz may oppose it based on the sanctions hearings that are pending. Okay. All right. Let's get to these Patreon transcripts. And how would Maddox fight this? I mean, Maddox should fire him for cause, and he should submit an affidavit to the court that he's firing him for cause. That's what, this guy advised me to do a bunch of illegal stuff. Maybe. If he did, kind of looks like he might have. But I don't know. We cannot know until we get some info, without getting into those behind-the-scenes discussions. All right, so here we are. Oh, excuse me. There are 15 pages of transcript here. I'm going to just read through them because, guys, these are glorious. Gatsgat says, flipping YouTube, I am subscribed. I smashed that like button and bell icon, but I still don't get notifications when you go live. Can we sue? That would be great, because I would love for you to get notifications, man. But I did announce it on Twitter and Facebook and Reddit, so you could also follow there. I don't know if you do. And it's easy to miss stuff on those things too, so I'm not blaming you. But that would help. Milk and Cookies Mama says, Rekieta Law looking sexy as always. Thanks for keeping us all informed and up to date. Thank you very much, Milk and Cookies Mama. I appreciate that. All right. Here we go. So this is the transcript. I don't got no Facebook or Twitter. I'm not a youth. We need to have a chat, Gats. We need to have a chat about stuff. I got to figure out how to contact you. Email me, Gats. Email me at my business email so we can chat, because I want to talk to you about something. All right, so the court. The first question so this is right away. The first thing Ramos says, the first question I have about this case is, why are we here? Don't we have some problems in terms of jurisdiction here? So he immediately knows. This is just Patreon Jordan Cope. He immediately is asking questions. So Skibble says, Your Honor, this is Reed Skibble for Patreon Jordan Cope. I agree. That's what I was planning to talk about. I can talk, or Mr. Landau can talk about it. Well, this is your motion to dismiss, correct? Yes. Should I read Landau's parts as Kermit the Frog? Because that's kind of how I picture this. Hey, thanks, Solid Snake 86XX. Oh, yeah, I have your Reddit account. But, yeah, email me because I want to talk to you about something in private. I know I'm bad at going on Reddit, so, yeah. Okay, so Kermit the Frog will be anytime Landau talks. And if there's... I want to say if there's a good super chat suggestion for Ramos or Skibble that I can do it. But that feels unfair to me because I don't know if I'll be able to do the impression. Because what if you send me something that I just can't do, and then that's a waste. That seems rude. I can't do a Scooby-Doo impression. Read them as Jordan Peterson instead. I'm not going to do Vinzini. Vinzini requires me to yell, and I will not do that in a hotel at 12:30 in the morning. Sorry. And so not Vinzini. Jack Nicholson. Solid Snake. No, I'd go with the original, like the Snake Plissken, right? Like to Hitler. I'd have to work on my Jordan Peterson impression. I think I could do it. Okay, so anyway. So, well, this is your motion to dismiss, correct? Mr. Skibble says yes. There's the lectern. We will hear from you first. Ramos voices Antonio Banderas. Do a Brooklyn guy for Ramos. Okay, I can do that. How do I get you to want to talk to me in private? Well, Lady Rackets may have issues with that. So, you know, we're... I love Lady Rackets and private chats with women are not something I do very often unless it's work related. So Mikhail Pospizczyk, are you coming to the Polish festival? What do you think happens first? Landau getting disbarred or Maddox moving back to Utah and never being heard from again? Oh, I think that second one, because I think Landau will just weasel his way out of it. All right, so Brooklyn. I gotta think of this. I gotta remember Newsies. Did the other transcript ever get read by a group? No, not yet. I need to arrange it. Keon and I are working on something, or were. We haven't really talked about it, probably because he's been busy and I've been busy. And I think I dropped the ball in replying to him. So that's my fault. I'll take the full blame, but it's not been done. But I think Dick is trying to get, the dramatic reenactment. Milk and Cookies Mama, I did because Mama is in your name, so maybe not though. Do Lure of the planet Omicron per se 8? I don't know that. Okay. Wait a minute, because like a Brooklyn guy is hard for me to just do. Okay, I'm going to read all Ramos's part as Peter Griffin. Peter Griffin. There is the lectern. We'll hear from you first. Does that work? Can I do a Peter Griffin? Is that okay? Your Honor, we have what I thought were 4 good reasons to dismiss this complaint, but I am really here to focus on personal jurisdiction because I believe it is evident this case belongs in California and not New York. Now, this is an online harassment case. It involves a dispute between 2 internet personalities, new media. Ramos is Cartman? No. New media. The plaintiffs are George Azunian, who goes by the moniker Maddox, and his former girlfriend, Jessica Blum. They're both residents of California. They work in California. Any communication from them took place in California, and any communications to them were received in California. Any injury they also had took place in California. So you're saying only women can be called mama. I see, sexist. Now, we represent 2 of the defendants. They're not the ones alleged to have engaged in any harassment. They are a website called Patreon. Patreon helps artists, musicians, creators, etc. make a living. Both Mr. Azunian and the person who is alleged to have engaged in the harassment, Dax Herrera, who goes by the moniker Dick Masterson, are users of Patreon. Now, Patreon is a Delaware incorporated company with its principal place of business in San Francisco. It has no offices in New York. It has almost no real property in New York. It has no employees in New York. It has no bank accounts in New York. All it is a website. Do Ramos like Judge Joe Brown. Yes, it has no bank accounts in New York. It is it's not owned by the oh man, Peter's hard to keep up. It's not owned by the plaintiff or defendant. What? It's not owned by the plaintiff and not owned by this individual defendant? No. If I do this as Joe Brown, we'll never get through this. No. Mr. Jordan Cope, who is the individual defendant, is a relatively low-level Patreon employee. He is a resident of California. He has never stepped foot in the great state of New York. He has never connected through an airport here. He has never come here as a tourist. He has zero connections to New York. What the plaintiffs allege, drifting to Joe Pesci, and I'm okay with that. Do it as Mo. I haven't heard Mo in like 10 years. What the plaintiffs allege, I can tell you what their allegations are that relate to personal jurisdiction. I can. The court is now Kermit the Frog. Oh, I just got to Landau. What about Skibble? Who should Skibble be? Do it as Cosby. They can have two. They say that we have some users. Patreon has some users in New York, as do virtually every company out there. I lose the Cosby after a minute. But you could add Joe Brown insults when he smacks Landau with the newspaper. Do Ramos as Nixon. Okay. Christopher Walken. Gosh, that's hard. Mo is Peter Griffin, but gruff. Also, I live in Rhode Island. Everyone there sounds like Peter Griffin. I could do, no. We're not going to do that one. Okay, anyway. They have some users in New York. So the court is Kermit now. What's Skibble? We got to figure out Skibble. Also, they said we have investors in New York, which is also the same, as virtually every company out there has some shareholders in New York. Skibble is Shatner. There is no connection alleged between either the investors or the users and the allegations in the case, which relate to a complaint that was brought by Mr. Azunian to Jordan Cope of Patreon. He essentially, Mr. Azunian said, look, me and the others are being harassed by one of your users on other websites, not yours, on things like Facebook and YouTube, and I think you should shut down Dax Herrera's account. He didn't like how that complaint was handled, which is why I brought this complaint against Patreon and others. Regardless of whether or not that states a claim, those communications took place from California to California. There's no connection between New York, the users in New York, or the investors. So wait, the court was Kermit, or the court was Landau is Bill Clinton. How about no voices? Aw, sorry, Andrew. Sorry you're not a fan of the voices. Court is Kermit. Who are the other defendants here? Most of the other defendants are collaborators of Mr. Herrera. Do everyone as Nick Rackets. Yeah, not everybody likes the voices. Not everyone likes the voices. I can get that. But I've been drinking, so it's kind of weird. Everyone is white noise. Okay, I'm getting off track. I probably need to wind the voices down because we got to get through this. And some people are going to listen to this later and really hate it. Okay, so who are the other defendants here? Most of the other defendants are collaborators of Mr. Herrera. I see. I take it some of those are in New York, or we don't know. There's one that's in New York, Mr. Asterios. I can't pronounce his last name. That's funny to me. The voices are good. The deliberating about the voices is bad. That's true. They're here tomorrow. They have many other issues. I don't know all the details, but I know he's at least in New York. The PR firm Weber Shandwick has some offices in New York as well, I believe. But you are just representing the last two defendants. I'm representing the two last defendants. Okay. Plaintiff, why are we suing these two defendants here? I didn't have one for Landau. Well, I had Kermit, but never mind. All right, Your Honor. Thank you for asking that question. Oh, sorry. I am going to do a voice for Landau because he reminds me of county attorneys that are like sniveling, and I hate that.
All right, Your Honor. Thank you for asking that question. To begin, just a point of clarification for the record. Now, a former girlfriend and not current girlfriend is another plaintiff, Jessica Blum.
So it's interesting here because we find out that they had broken up prior to any of these hearings. Does she have a name?
Jessica Blum, yes. That has since been amended, I believe.
Okay.
Patreon is not just a website, as Brother Counsel would like to explain. It is a platform. It has raised $107 million of venture capital for their operations of this fund, $60 million of which was raised by Thrive Capital, who is indeed...
Counsel, there are a lot of companies making a lot of money and do business in a lot of states. It doesn't mean that they can be sued in every state of the nation.
Your Honor, if you will allow me the same latitude to explain as you did defense counsel, then I think that we will...
Just answer my question.
The personal jurisdiction is derived as a result of multiple connections to New York. They have tens of thousands of users. Among those users and creators, one of them is a resident of New York, Stereos Kokonos. The other one is a book deal and has property.
Really? Has property?
Dick Masterson, his moniker, and his monogram that is owned by publishing companies within the state of New York.
Dick Masterson is not owned by publishing companies within the state of New York. Note the voice is satire, no Mad Cuck's suit. That's not owned by the defendant.
Pardon?
You're not saying the defendant owns property here.
No. The defendant is a platform.
You do the White Meyer Kermit? The defendant is a corporation. I don't care what it does. It is a corporation. It is an entity.
In Delaware, correct.
It doesn't have an office here. Doesn't do business here.
It does do business here.
How does it do business here?
They have a sophisticated banking and payment process services. They act as agents for each of their users and creators. Tens of thousands are located in the New York area. Among those, Mr. Kokinos is a resident of New York and also a defendant of this lawsuit. In addition to that, Mr. Herrera, who is an additional individual defendant, does a substantial amount of business here and makes a lot of money from...
He is not the one making the motion. The corporation...
Your Honor, they are all interrelated, though.
Excuse me? The corporation and an individual named Jordan Cope are saying, why are we being sued here? You want to sue us whether you have a claim or not? Sue us in California.
Patreon has up to and including 40,000 New York-based users and creators. That more than sufficiently...
No, it is not. It is not sufficient at all. Look, there are companies in this country and overseas that have customers and have dealings with people in New York. It doesn't make them subject to jurisdiction here. We have constitutional requirements.
Your Honor, from our position, the standard in opposing the motion to dismiss pursuant to CPL 3211A8 is on the grounds that discovery on the issue of personal jurisdiction is necessary. A plaintiff need not make a prima facie showing of jurisdiction, but instead must only set forth a sufficient start and show that its position is not frivolous.
Hold on. Hold the phone. Hold the phone. You have to have some basis upon which I can conclude that you have a valid claim for jurisdiction in New York. This is not a fishing expedition.
Our client does business in New York.
Your client is the plaintiff. I am concerned about the constitutional right that these defendants have not to be sued in New York. Can be sued in another jurisdiction, that's fine. I think as a jurisdiction, if I am not mistaken, your client lives in California as well, correct?
Correct, Your Honor.
Is this... Just a minute, guys. This is great, right here. Is this harassment? is this harassment. He calls him out on it right away, and Landau has to immediately be on guard. Immediately. Because at this point, we have a danger signal going off. And I am getting a little tired on the voices. Sorry. It does get pretty tiring. So I'm going to probably finish this out just regular. So if you enjoyed the voices, thank you very much. Maybe I'll do like, maybe I should do Patreon rewards and read whole things in voices where I can rehearse it a bit and clean it up. Anyway, let's push through. Is this harassment? Pardon me? Why are you bringing the action in New York? Why not bring this action in California? As it relates to these two defendants, Your Honor, yes. Well, as I've been trying to explain, it's a little bit more complicated than just a linear binary type of situation because they have so many different types of people. Users, creators. You are not answering my question. You're getting back to your original argument. I know that's what you're prepared to do. I get it. I understand that, he says. But I'm asking a very simple question, a logical, strategic question. Why doesn't your California plaintiff sue the California defendants in California? Is it that you can't get jurisdiction of the other defendants? Well, jurisdiction is natural. Listen, this is brutal. This is a brutal announcement here. This is a brutal, or not an announcement, a brutal admission. Jurisdiction is natural over the other defendants. California has jurisdiction over everybody. Maybe a Patreon tier for no voices since I'm already a patron. Why? Wait, do you want voices or not? Okay. It's what? National? Personal jurisdiction would be natural based upon their direct ties. Yeah. So that's what that's what Ramos is getting at here. You were saying, are these other, Foundation Digital, where are they? I don't believe they have any offices, but as far as their interactions, what about Greg Bozer? Where is he? They're part of Foundation Digital. They have not been served yet, but Foundation Digital has. Actually, I think Greg Bozer was served. Lauren Baker wasn't served. No. Greg Bozer was improperly served, as was Foundation Digital. Lauren Baker was never served. Where is he? They're part of Foundation Digital. They have not been served yet, but Foundation Digital has. Not really. Dax Herrera, he has direct business with New York. Weber Shanwick. Mr. Herrera, he lives in California, doesn't he? He does. Lauren Baker, is a he or a she? I don't know. I believe a she. I'm not sure. Lauren Baker is a he. Do you know where she lives? I believe in California. I am not certain. CM, she has not been served yet. How about CMGRP Incorporated, whatever that is? That's Barbara Shanwick, the brother of Weber Shanwick, or the sister of Weber Shanwick. They have offices in New York. What are they? They're a large PR firm, and that's owned by a publicly traded company that's on the New York, the NYSD, which I guess he means the New York Stock Exchange. What's their connection to the claim? That's tomorrow, so I am asking a question. I expect an answer. Like that. If a judge asks you a question, you always give an answer. Andrew Shuggett says, thanks for kicking my butt, dude. These streams are excellent entertainment for me. Well, thanks, buddy. I appreciate that. I'm glad to entertain you. I'm asking a question. I expect an answer. And Ramos is getting a little annoyed here. Sure, they are the employer of Asterios Kokkinos. Many of the acts and conduct that Mr. Kokkinos has performed throughout Joshua Kaufman, also a New York resident, yes, he is counsel of Barbara. They're coming to get you, Barbara. Kokkinos, you've talked about that a lot. He is a New York resident. Who is he and what does he do? Well, that's a good question, right? He is, I believe it is called, a senior copywriter at Weber Shanwick. He is used during business hours of their equipment. What a weird way of saying stuff. The Diggist says, first time catching the stream. Sadly, I'm heading to work and have to keep watching the VOD later. Greetings from Germany. Greetings back to you from Texas, buddy. Have a good day at work. I'm not going to do Skivel as Mr. T right now. So he has used during business hours their equipment. So apparently Landau should have been Yoda the entire time. I apologize. Their technology at the employer Weber Shandwick throughout this campaign of harassment. You were saying he is a part of this harassment? Very much so. Trevor Burt. He is affiliated with Patreon. Is he not? So that's weird because I think that is supposed to say the court there. No, Trevor Burt is another person that has not been served quite yet. Quite yet. Way beyond. Way beyond. YouTube, yeah, I'm in Texas right now. I'm in East Texas. He's way beyond the deadline for serving Trevor Burt. I don't care if he's been served or not. What is his relationship to the litigation? See, one of the participants. He is a proponent of harassment and so on and so forth. It seems to me that you're alleging that these other folks have committed a tort or torts directed at your client. All of them, yes. Wouldn't you have jurisdiction over them in California under the California long-arm statute? Yes, we believe we do. To Stephen Hawkins. I still don't understand why an action is being brought in New York. Does the fellow come to New York a great deal, your client? In this litigation, he's going to have to come here a lot to be deposed. As he will, Your Honor. They satisfy the minimum contact. All right. Put aside the others. Whether they've been sued in California, I don't care. I'm concerned about the two defendants moving here. Is this as hostile as it feels? Yes. Yes, this is absolutely hostile. Not good. Not good for him. Okay. I'm concerned about the two defendants moving here. Yes. What are you alleging that Mr. Jordan Cope has done to your client? So there's a series of correspondences between, I have seen it in the file, but what has Mr. Cope done? During such correspondence, he had made deliberate and intentional claims that listen to the legalese that he's trying to, it's all conclusory. It's all this weird, legal language. He's talking to a judge. It's like he's trying to impress a crowd at a bar, but deliberate and intentional claims that it was being referred, that it was being handled, that his complaint, by him I mean our client, his complaints were being addressed. During this entire period, his girlfriend and him were his girlfriend, ? Plaintiff's girlfriend and himself. So Ms. Blum and Mr. Azunian advanced a series of harassment techniques. Wait a minute. That's a weird statement. Jacob Ceresia says, we're done? What's up, buddy? What do you mean? What do you mean we're done? This is such a weird statement. So Ms. Blum and Mr. Azunian advanced a series of harassment techniques. His girlfriend was called racial slurs. Rape was threatened. I just love the judge. Oh, yeah, at the end. Yeah, we're getting there. Rape was threatened. By Cope? No, Your Honor, but through counsel. Please. You are trying to bring Mr. Cope in on a long-arm statute, correct? I have to know what you are alleging Mr. Cope did. I'm trying to provide context. It is really... when you see the ... like that in this document, just imagine this. It is really... Mr. Cope did this. You tell me what it is. Mr. Cope, he sent an email. Well, through email correspondence, yes. Mr. Cope advised our clients that these matters are being taken care of. They were being referred to the proper channels, both their trust and safety department. Mr. Cope is lying. Is that a tort? It is. It is? When did lying become a tort? The judge doesn't even understand where this guy is coming from. Given the nature over a period of time, he was intentionally misleading our plaintiffs to placate to them because it was apparent that Patreon was valuing Mr. Herrera. How are they being damaged by his saying it was being taken care of? There has to be damage. We're talking about a tort. How was your client and his girlfriend damaged by the fact that Mr. Cope says it is being taken care of and it wasn't being taken care of? It wasn't. All right? The motion to dismiss Patreon Inc. and Jordan Cope is granted. Their enjoining them and defendants in this case was frivolous and in bad faith. Thank you very much. Motion is granted. I didn't even get to the terms of use. We're done. We're done. That's it. That's it. Like, this sentence right here, they're enjoining them as defendants in this case was frivolous and in bad faith. This, remember, the next hearing is the next day. And it seems like Landau is terrified for most of it. Based on the accounts, he is really, really trying to be as careful as possible. He takes long pauses. He has this little munchkin to help out with research or whatever. He has got to be concerned. Remember, he's filing sanction motions for frivolous actions. The court has the authority, based on this frivolous and in bad faith, the court, in theory, could impose sanctions against Landau without a motion. They have that authority. He didn't take it in this case, but he could have. He could have. Bet the break between lines 9 and 10 were Landy frantically shuffling papers. Probably. So that's it, guys. The Patreon hearing clearly did not go well for Mr. Landau. Very, very uncomfortable. It feels uncomfortable from a read. You can feel the judge's disdain just dripping out of all of it. He's not a fan. You think Landau's a sadomasochist? Possibly. Or, some have speculated that Landau does this. Some have speculated that this is his MO, to basically skirt the line of doing the minimum amount of work to justify billing, with no, with losing every case, with barely even representing people. That's a possibility. And if that's the case, maybe he's just comfortable with having a judge hate him. But it's always a little weird when the court isn't buying a word of what you're saying. That's why the judge was like, it is, which means no, it's not a tort. You flipping. Yeah, exactly. Yeah, Clay. This is bad. This is bad. That sounds like more effort than just representing someone. It does. It does sound like more effort than just representing someone. The difference is, if you have no illusion that you're going to win, then you have nothing to lose, right? You're just collecting money. But I don't know. It kind of looks that way. I can't find cases that he wins. I found, there's some cases that he settled out. We don't know what the terms of the settlements are. We have no idea. The real lady racket says so much fun. Really? I wonder. But anyway, guys. So that's what there is. Brandon B says, I'd up Patreon if you had amateur voice actors read ridiculous transcripts. I don't know about Landau, but Maddox obviously thought he had a chance of winning. But Maddox could have been sold on that chance of winning. Do you really have to wonder? I do. It's the internet. I have to wonder everything. Okay. Homeboy, I'm hitting you up for a beer soon. I need to visit a couple friends where you have your office. Well, yeah, let me know when you're coming into town, man. Absolutely. I think I just had an epiphany. Landwy adds all those commas and apostrophes to pad out the motions. Oh, that might actually be the real Lady Rackets. That's terrifying. Well, real Lady Rackets, I should probably wrap up and come to bed, right? Like it's late. It is late. Is that the business office at the hotel? It is. It is the business office at the hotel. Well, guys, I think I am going to wrap it up. Will you legally teach us how to fully delete McAfee antivirus? That's Patreon's material. The legal way is to borrow Mike Cernovich's flamethrower and just torch your computer. Drink more and do more voices. The voices seem pretty polarizing. You made that sound really creepy to all of our friends. Yeah, when come to bed, I mean literally go to sleep, because it's like 1 a.m. and we have a lot of driving. So anyways, guys, I think I'm going to close out the stream. Good stream, at least what I caught. Watch the start tomorrow night. Yeah, thank you all for joining, of course. And I appreciate all this. I really didn't anticipate doing 2 streams in a row on vacation. I do not anticipate doing another stream tomorrow night or anything like that, because I'm trying not to spend my entire vacation on YouTube. But this document drop was just too juicy. But of course, when I get back home, there will be a schedule. Drink some whiskey and stream while driving. All right, guys. You have a wonderful evening. I'm going to go pretend I'm not sunburned and get ready. Oh, real quick. If anybody is in Texas or near Texas and wants, I will be in Bremont, Texas, Friday and Saturday for the Polish Festival. Come join me. Come eat some sausage and barbecue and drink beer and whiskey. I'm talking to you, Jamie Hughes. It's not too far from you. So come out and come out to the festival. Hang out with Lady Rackets and I, and we'll have a good time. But let's see. Another beer will help me steer. Oh goodness. Yeah, seriously, Jamie, if you're gonna come out, just message me or something so that I can tell you where we are and come meet us. My cousin will not be with us though, but she is here in town. Well, perfect. Don't wait till you get back to respond to your email. I won't. I've already seen it on my phone, buddy. So, all right, guys. Bremont's a 3-hour drive for me. Well, if you want to make it, I'll be there both Friday and Saturday. So just let me know. We can all take a picture on Rekieta Street or whatever. We're done. DFW Nights. Where in Texas to have a washing machine repaired? Man, I have no idea. Oh, and one more plug for my dude Pizza Wolf, who seems like he missed the stream tonight, but he'll watch this later. Breaking Brew Meadery in Dallas, near the Galleria area. They're not open yet, but when they do open, go check them out. Have some mead. They have a bunch of different flavors. Good stuff. So, all right, guys, I'm going to blank out the stream. Once it goes blank on my end, I will go ahead and shut it down. I will upload the audio as soon as I can. I don't know if I'll be able to do it on vacation or not, but thanks for watching. Thanks for hanging out. Thanks for liking and hating the voices and all that stuff. So, you guys have a good night.